And now we welcome Jane Matz and Stacey Carter. We're really pleased to have you. And if you're making a joint statement, we're happy for you to handle the matter that way, or simply, Jane, if you'd like to make your statement, and then we can include Stacey in the questions. Now.
All right, I'm very grateful to have this opportunity to speak to you. I just want to apologise. I'm living in a renovated house that was flood affected in the Ugara area. So I've got a blanket over some very important pieces of development happening in this particular room. Look, yeah, very grateful to be here. And Stacey and I work together, and we do a lot of presentations in relation to what's impacting women in particular, to the legislature, and in relation to policy and policy development. So just a bit about myself and the Sisters-in-Law Project. We're a group of lived experience women, mostly women. There are some men that do help us, who are involved in some form of change in relation to domestic violence, as it's specifically for family, in relation to family law. We directly support women through the family law process. And for myself, I personally assisted in 42 applications in the last 12 months of 23 women going through the court system. So that's either helping them because at the last minute they've had to self-represent, or but mostly linking them in with some form of legal support so they can move through the system. So what we're reporting on is what we observe. So while Stacey and I are both law students, we're not lawyers. Nothing that we say can be taken as legal advice. We're aware of CEDAW and the requirements and the articles within CEDAW, and I guess we've got some key recommendations that are sitting in our presentation to you. My background is that the reason why I do this is because I've been involved in family law myself and saw some terrible, and I know that I've seen your list, you've got other women coming through talking about the things that have happened within the family law system. And one of the biggest problems for us, is that we're trying to find the right steps forward to make the changes, so the voices of women and the impact around domestic and family violence in particular, and child sex abuse in Magellan, is managed a lot better. And that includes linking that in with state systems, obviously protection orders that we see also go a bit skewy from time to time. But the other part of it is, and I also want to bring to the committee's attention, is that we see the worst things. So there's good things happening in this jurisdiction. We're seeing, but mostly some of them are terrible things that are happening to women and their voices and the conduct of proceedings. So getting back to the statement as I have it here, one of the things that we're seeing is the impacts around access to justice for women. One of the key problems that we're seeing is that legal aid is poor. I've got a mum at the moment that I'm assisting who's got 102A funding. She's trying to get to a trial. She's got 2 lots of legal events coming up. She needs a lawyer now. She doesn't need a lawyer 3 months before a trial. And in fact, because there's been serious domestic violence in this particular matter, it has the potential to go, the evidence may not be put before the court in the right way, and therefore there's gaps within the 102A funding, which is cross-examination funding to support women going through domestic and family violence. There's issues with accessing long-term medical help, accessing funds, because when it comes to being legally represented, women predominantly have less funds than what men do as a general rule, and therefore, rely on either legal aid, or they can't access any form of legal aid because their money is tied up in assets. So therefore, this is where we've been coming in, assisting women to either get some form of funding so that they can leverage off that to get legal assistance, but sometimes it's all too late. There's poor stability around housing with some of the women that we're dealing with, and in fact I was made homeless in my own process because money was locked up. And intentionally so, and it was the system itself. One of the big things that came out of a recent conference that I presented at in Wollongong was that we as women are finding in our family court system and state systems that this very systems that are set up to support us are actually they're not doing their job. And in fact, they can be more destructive than the domestic violence itself. In fact, I would say, and Stacey will probably come to this very shortly, is that one of the biggest problems is that many women can't go back to work. The trauma and the impact of systems, the impact of the domestic violence is so significant, and the processes of support and the lack of proper legal support for some of these women leads to long-term health issues. And I think that we need to do a lot more in that space. I would love to see, as a general rule, just to see more in the legal process around embedding CEDAW in the Family Law Act. Our Risk Screening Protections Act needs to be amended to allow for formal risk assessments to be put before the court, because at the moment there's a legislative provision that says under 10V that you are not allowed to actually put risk assessments in the Lighthouse project before the court. And it goes before the registrar, but not before a judge. And lived experience needs to drive change, and I'd love to see more women involved from a lived experience perspective to drive change. 102A needs an amendment because the mandatory provision is stopping some women from putting their evidence forward because their 102A lawyer won't allow them to do it, and if they object to it, then they actually some of these lawyers are walking away and leaving women so that they cannot present their matter before the court. Transcripts within family court systems and being able to appeal is almost impossible for the majority of women I'm dealing with at the moment. It's a recent change that it's a mandatory provision to have a transcript. Recently, a mother had a quote for $19,000 to get a transcript for an appeal. I'd like to promote legal caseworkers. Family report writing needs serious amendment because, these one-off reports are actually making some serious challenges to women's credibility, especially calling them enmeshed with their children rather than using the term called realistic estrangement. We have Jennifer Neo at the moment running a RIFT program, which is undermining the impact of trauma, and family unity programs tend to be a problem within Australia, as is, and I know Janine Rees will talk to this, the whole parental alienation rubbish that tends to be used against women. So I'll just leave it at that and hand over to Stacey, and thank you so much.
Good, thank you very much. Thanks, Jane. And now over to Stacey.
Hi everyone. So as Jane said, I'm one of the founding members of Sisters in Law Project with Jane. I've been working with her for the last close to 3 years now. My role in Sisters is the Community Engagement Manager of Lived Experiences. So we work very closely with mothers who come to us for their support. We talk to them about their experiences that they've had with domestic violence, and particularly how that flows into the family court matters. So we're there to, it's a two-pronged attach. We're able to assist them to pull materials together for court if they're self-representing, to help them tell their story. And also for us, Jane and I have been very active in telling the lived experience of ourselves and other mothers as well. And it's a really big part of the education for people who are working in this space, that they do take on board lived experiences. And I think Jane sort of touched on this before. It's really important that we start to maybe train the people who work in child protection and family law by using lived experiences. I myself, I'm a mother. And I'm a survivor of coercive control and family domestic violence. My children have also experienced family domestic violence, including child sexual assault. And I have experienced firsthand some bias and discrimination during my proceedings with family law court. We're seeing that the narrative is often really the same, that when mothers are in similar situations to us and they're trying to navigate court, many mothers are experiencing DV, and the situation actually worsens after separation and when they enter into the family court. And then they're also having to put up with the unfair processes and systematic abuse while they're in the family court arena and actually dealing with police and protective services. Many of these mothers are what we refer to as a protective parent. and where evidence of abuse is actually ignored by the family court, and we're seeing them losing their children, particularly where there's allegations of sexual abuse. The family court doesn't seem to recognise or understand the significance of the motherhood and the role of upbringing her children, and the bond that should be foremost consideration for the best interest of the children, i.e. the primary attachment, which is the mother. We are seeing that the family court doesn't seem to recognise that women have equality before men as part of under Part 4 and Article 15 of the CEDAW, and also we refer to Article 16, where it states that parties should take appropriate measures to eliminate the discrimination to family marriage. But we're not experiencing, those mothers in court are not experiencing that. They're not afforded the same rights in many relation to the guardianship. It's not exercised at court. Women and the children are being failed at court in a few ways. There's a drawn out family court lengthy process and costs. So some of these matters are running for 5+ years. So not only is that highly traumatic for any of the parties going through court, but it's also the impacts are on the financials for the women. Their lawyers can cause a lot of issues for them, whether they're private or legal aid. And the problem with legal aid is that it's limited with their funding, and it often will not cover appeals for the women. We're working with my mother at the moment, and she was not able to access legal aid because her ex-partner had legal aid, but he actually had legal aid and he was a really high income earner. So there's a lot of discrepancies in there, which is unfair for the women. Some of the other issues we face are what police and protective services do or don't do. Sometimes it hinders their matters, and sometimes it does help. A big thing is the way that family report writers, the children's lawyers and judges actually interpret evidence of domestic violence, or they actually dismiss it altogether. Jane touched on that as well. One of the mothers we're working with, she's got 2 children. She's been in family court for about 5 years. There was a lot of evidence of domestic violence and abuse in that matter by the father. Evidence of, and there was AVOs and convictions as well. During the court process, when her daughter was around 5 years of age, she actually disclosed sexual abuse to her mother. She went on to disclose it to other family members and her counsellor as well. And of course, that instigated a child protection investigation. However, because the matter was already before the court, and the court had actually already flipped custody, so to speak, because she dismissed previous allegations of domestic violence, the child abuse protection investigation decided not to pursue the matter. They didn't interview the father, and they said that because the family court orders have been made, the family court overruled the AVO. And of course, that's not actually the case. The AVO is there to protect the parents and the children in this instance, and it should overrule the family court orders. As a result of this, she struggled with the court. The father had put in an application for the mother not to see the children because it was deemed that she might be a psychological risk, because she was taking her daughter to medical examination and interviews with the police and child protection as ordered to do so by those agencies. And then because she did that, that's a psychological harm to the child. The court took this upon themselves to agree with that, and the mother lost custody of her child and the elder sibling, because it was a risk that the daughter may discuss or seek help and guidance and support from her mother and family regarding the sexual abuse, and that the court seemed to deem that was more important than the fact that the risk that the child abuse had actually happened and could continue to happen. That mother is now working closely with Jane and I. We're trying to secure some support for her so she can take the matter back to court. She's been unable to appeal the matter because the cost involved. So to go to an appeal, you can't get the legal aid in most cases. And the lawyers have asked her for about $50,000 up front, I think it was, to start the proceedings of an appeal. And then, of course, the answer is an appeal might be 50-50. You may or may not win your appeal. And if you lose your appeal, then the mothers will be up for the cost of the father's cost in court as well. So that's an additional financial burden. From a sisters-in-law point of view, We believe the court really comes from a position of disbelief for women who claim the DV, because most of them are going in thinking it'll protect their children, but the outcomes are actually the opposite. Sorry, I'm just having a look at my notes when I want to get to important stuff. So some important facts. More than what you're probably aware of this, most of you, more than 1 in 4 Australians have experienced child sexual abuse. Up to 90% of child sexual abuse is the offender is known to the family or is a family member. 98% of child sexual abuse reports by the child are found to be true, and children will often disclose long after the abuse has started. An offender can use this behaviour, such as accidental touching or tickling. In the case of the mother that I referred to before, a police officer actually told her, oh, the father was probably just tickling her. So there's this, it's not just in the court systems, it's the police and the child protection not believing where it's coming from the mother. So outcomes for as Jane said, for a lot of our mothers who are facing or going through these processes, whether they're losing the children or they're only having supervised contact or very rare contact. Sometimes contact can be only monthly. Some mothers are only seeing their children a few times a year. It's severe depression for the mothers, PTSD. Jane touched on it before. A lot of these people are unable to return to work because the trauma is too hard. It's impacting on their ability to stay in gainful employment, and it's impacting on their relationships outside the court as well. So that's why this message is really key for us to get across.
Thank you so much. I've just got a comment and then over to my colleagues on the legal aid issue, because one of the problems I think in the legal aid area is that there tends to be a presumption that legal aid for criminal matters is more important than legal aid for family law. Now, what we know therefore is that legal aid is skewed towards men, because men are more likely to be up on criminal charges, and it's skewed against women because women are more likely to be in the family court and in financial difficulty. So we need to actually look at what's driving the legal aid funding relativities. That's number one. But number two, legal aid came in. I have to give the former Justice Lionel Murphy of the High Court, when he was Attorney General, he drove that issue that we needed to have legal aid commissions that would look properly at the whole legal aid budget and so on. And unfortunately, that's all been undone. And that's why you're citing these instances of a lack of access to justice, because the legal aid is not there for women. Yeah.
It's a significant problem. What we do, like I call myself and Stacey, we're legal caseworkers, and what we do is we help women through the system if we can, where we can, and link them in with lawyers. And if you can't get a legal aid lawyer, then I suggest that we try some form of pilot for women like ourselves to help pull the materials together, give a sense of self, what's going to happen within this system, and help women walk through the system. It makes it easier for the court system to be able to see the core part of what we do is a timeline, and we pull together a folder of material. So when they walk into a lawyer or the duty lawyer, the time is well spent. And the problem is that some of that time isn't enough. For domestic and family violence survivors, their matters are often complex, and we're not providing enough time to be able to manage that well. And let me just say, conversely, as part of that, we're expecting lawyers to deal with and most of them are women in the family law sector, to deal with complex trauma and not support the lawyers in dealing with these stories of women. And it's cyclic, and I think we're not looking at that enough.
Just quickly, Mackenzie's Friend, that's the name of advocates who do appear in the criminal system, and I know that in England they appear in other areas too. But now over to my colleagues. Any questions?
Yes, I've got one. Is the legal aid at the completion of or what they consider the completion of the court processes, is it claiming the money that they've helped or they've supposedly supplied back to be repaid? Because
yes, in some circumstances they are. But the other problem is with legal aid is that when they have like FDR and they're doing some form of mediation, if you go through legal aid New South Wales in particular, they've only got 4 hours, funding for 4 hours. And most of these complex matters that I'm dealing with, they need probably 3 lots of 4 hours. You know, what's being set aside for legal aid is not enough to get a resolution. And, you know, you talk to some of these lawyers, they get $150 to appear in over a 3-month period or 4-month period, and that's it for an interim hearing for legal aid. I think the course structure, and I know that we're all trying to work towards better cost management, but that's not being, you know, that's just not enough. But it's getting back to the Mackenzie friend mention what you were mentioning previously. I do that, like, well, Stacey and I do that. We offer ourselves as Mackenzie friends. What I've suggested from a legal caseworker perspective, for those of us who are law students and capable, to assist with mentions and directions hearings. And it'd be nice if we could get permission beyond the Mackenzie friend, some form of accreditation process, but linking in with the duty lawyer, because one of the biggest problems is they cannot get a lawyer for mentions and directions hearings. And there's complications in that space, and I think that law students could benefit from that as long as they're linking in with the duty lawyer.
That's actually a really good idea, and it should be raised. Surely, which law school would you be closest to in Queensland? You're in Queensland, aren't you? Or here?
I'm in New South Wales, and I'm at Southern Cross University, and Stacey's at the University of Canberra.
Well, do they have a law clinic? Because the law clinic should be actually taking this up with the legal authorities to see if it can be worked out. Yeah.
I get that, but what happens is the issues are when they're at court, when they have to go to court, or they're sitting online. You know, sometimes they don't know what to say. I had one mother, when I was sitting with her, that she was so traumatized and so scared by the experience, she couldn't even say a name. And because I was sitting with her in front of the computer, and I just said, I asked permission from the registrar if I could actually address the court, which was given to me. And then once we started, she got to talk. But I think it's really daunting for some of these women, because most of these interim hearings at the beginning, they're all online. And, you know, some of those, we need to think beyond what we're doing at the moment to better support traumatized. And I've had some men too, I just want to add, you know, some men in the same situation. We need to manage that initial period, I think, when they're first responding to initiating applications a lot better than what we do. So FDR is when you're negotiating orders and going through, you know, some form of process of trying to get consent prior to any further litigation.
Thank you. Stacey.
Yeah, so I just wanted to go a bit further to what Jane was talking about as a Mackenzie friend, and the value that would be that a Mackenzie friend would be allowed to speak on behalf of a traumatised mother in court. I was very grateful to have support for Jane when I was going through my own family court matter, because it is traumatising, and we get better at it, and now I'm helping other mothers as well. But a lot of the time they can't afford to access that lawyer that we may be setting up with, and they only get the duty lawyer and they can't get legal aid. So they're actually self-representing their matter from the beginning and until the end, with some help from Jane and I, for example. So, but it is, the trauma comes in when you're put on the witness stand. So I'm going to tell you that from personal experience. I'm actually quite a confident person, and although I've suffered a lot of trauma myself, I was reduced to tears on several occasions on the witness stand and was absolutely intimidated by our judge. So I can only imagine how some other women who perhaps are not as confident as Jane and myself are, how they're feeling. So having that support person as a Mackenzie friend who is able to speak for them and articulate for them when they can't use their own words out of utter fear, that is really, really important.
Good. Now over to Mary, Helen, Kerry, questions? We do have a bit of time.
No.
So question. So obviously once the court case is completed in these instances, these women, I'm guessing there is no support, like with counselling. So they're obviously dealing with their own trauma and the effects of this, and there's literally no one there for them.
So they've obviously, so most of them obviously get 5 free sessions. And by the time it gets to the end of the hearing, those 5 free sessions are all used up. And I think we were lucky enough, the Sisters-in-Law Project, Stacey and I, and there's a group of 9 of us that presented to the Children and Young Persons Committee of New South Wales. And there was a paper written that came out in December last year about dealing with cross-jurisdictional conflict between New South Wales Child Protection and Family Court. And they actually described it as a misalignment. But one of the things that came out of that, and it's a really good point, is the need for ongoing psychological support for women, you know, within these systems, especially when they're dealing with Magellan matters. You know, I've had one Magellan matter where there were 29 risk of significant harm and 2 substantiations, and the mother was deemed to be making it up, you know, being the centre of attention. It was just physically not possible for her to do that. But in saying that, she needed a lot of psychological support because the systems were just treating her very poorly. You know, it was systems abuse on speed. But in the end, she won her appeal. And just so that you know, here's a classic example of what can happen in this system. Is that 6 days before her summary of argument for her appeal, her lawyer withdrew. She decided that she just needed to get the evidence out there. We sat down together and we pulled as much as we could of a summary of argument. And she, on the day that it was due, we submitted it 1 minute before it was due. On the day that it was due, she got a legal advice saying that she would not win her appeal, and she did. She went on and won it. And, you know, we have systems here that are not supporting women with, like, I'm not an appeal expert, but I would have thought this appeal had very, very good merit, considering the evidence that was filed to be put before the court. So I think that we're not doing enough for women for appeals, and we're not doing enough for women to support them through these systems, through their medical requirements. And I think that it'd be great to try and create an alternate system than an adversarial family court system for those who've experienced domestic and family violence and child sex abuse.
Can I just clarify, the Magellan project relates to child sexual abuse within the family, and it's supposed to prioritise those cases. It's just that people out there, you see, aren't familiar with this, so they won't know. As I said with FDR, they don't know. You know, because you've been through the process and you're law students and you're doing what you're doing, but we always have to clarify for people out there. Yeah.
So Magellan has a Magellan protocol. So there is a process that the family court follow, and there's supposed to be a memorandum of understanding between the family court and state child protection. But what we're finding is that through this Magellan child sex abuse review within family court to determine, you know, parenting orders, that there's a misalignment and in line with what the findings are of that committee in December last year. Women who are doing exactly what the state tells them to do are losing their children in family court for following the guidelines of state child protection.
Helen, did you have any questions?
And I'm happy to provide some case authorities if you would like.
That would be excellent. Really much appreciated. Thank you. Yeah. Now Helen's got something.
My question is just about parental alienation. That this has really become, you know, a huge issue when it wasn't, say, 50 years ago, I think. Well, I shouldn't say it wasn't 50 years ago, but it wasn't taken notice of to that extent. Can you talk a little bit about your experience of the use of that term, theory, and its impact on women in your experience of the courts and so forth?
Go, Stacey.
Do you want me to talk, Jane? Yeah. In my matter and some other matters, because the judges make determinations that the DV hasn't happened or they've dismissed it, and actually doing custody changes or actually removing the child, that is a court-ordered parental alienation, and it goes beyond the mother not having access to the children and being alienated from the children. It extends to grandparents and step-parents and the broader range of, you know, family and close family friends. So when a change of custody happens, the child not only loses the mother, they lose their whole world. And the thing is, what we're seeing is that what fathers are doing is when mothers come to the court with evidence of severe family domestic violence and in particular child sexual assault, the lawyers for the father automatically go, oh, the mother's alienating the children from me, she's making up these stories. And in many cases, the mothers will withhold access from going to the father because they've been advised to do so, whether it be by child protection, police, or you know, their lawyers themselves. And sometimes there's AVOs, sometimes there's not. But there's it's called it's reasonable grounds that you can withhold a child from seeing the other parent due to severe domestic violence. And in many cases, Jane and I have seen that reasonable ground has been simply dismissed and the mothers are then contravened.
Under the Family Law Act, and again, I'm not a lawyer, but I'm just saying this is what I'm seeing as it's applied. There's a section of the Family Law Act, which is why I don't like. I'm against the SPR being removed. You know,
sorry, Jane. You mustn't say ESPR. You've got to spell it out.
Equal shared parental responsibility. And the other side of what can happen in orders is called sole parental responsibility, which is quite rare. So under equal shared parental responsibility processes under the Family Law Act, it's, you know, that what we have, if there's domestic violence under section 61 DA2B, they can actually suspend equal shared parental responsibility. And I'm not seeing the court do that when they make findings of family violence in the matters. And again, I would like to point out the fact we see the worst ones. So it may well be happening in other matters, but in some of the matters that we're working on, then there is the lack of application of that particular part of the Act to suspend equal shared parental responsibility when there is domestic violence. And the other one is under section 60 CG of the Family Law Act, where there is a state protection order that the court is supposed to follow it as much as they possibly can. And I see from time to time that the courts fail to do that as well. And I guess it is of concern that there's no oversight in relation to that in some of these court orders that are made. And so it comes back to that same thing. If a mother wants to appeal, she's got to find an amazing amount of money for a transcript. And it's really hard to challenge, you know, the failure to apply the law when these provisions in the Family Law Act aren't applied. And I mean, I've got some great lawyers, but no one can work for free, you know. So that's very rare to get funding from legal aid to run an appeal.
And I suppose the problem is that at trial, the right result doesn't come out, because if it did, you wouldn't need to appeal. That's a real problem in the system. Yeah. But over to Kerry Heubel. Kerry, did you have a question?
I don't actually have a question that I think any of us could answer, other than to say, why does a transcript cost so much money? The government is there. It should be providing these transcripts.
Absolutely. There is some funding that's available by the Attorney General, and I do have mothers that we do apply, but my success rate, and I think in the last 20 applications to the Attorney General for transcripts is I think it's like three people out of 20 odd people have got their funding.
But why should they require it? I mean, that is their job.
It's privatised. It's all been privatised. This is the problem. The transcription services are run by private companies. Private companies have to exist on profit. That's the reality.
I realise that.
No, I'm not saying it's a good thing. I'm saying it's a bad thing.
But the idea of privatising it is so the government doesn't have to do it, not that the government doesn't have to pay for it.
Yeah.
And I see the issue of if someone needs a transcript, That's the government's job, whether it's privatised or not. It's there, it should be given, it should be available. Otherwise, it's intentionally inaccessible.
Well, I have a mum who yesterday reported to me that her protection order was ignored, and she wants to appeal, and her on an interim basis, and her cost for the transcript is nearly $7,000 just for an interim hearing. It's impossible. She cannot afford to do it. She's applying. She said she's applying through the Attorney General's application process to get money for it, but it's probably unlikely that she'll get it.
I suppose the point is that we have to seriously look at stopping privatisation of public functions. This, as Kerry Heubel says, it's a public function that should be undertaken by government. And then government would actually be saving money, not spending money, because if they're paying for transcripts, they're paying for the transcript plus a built-in profit component. But there's so much that you've raised that's really vital and important, as with all our witnesses. And there are matters that we would like to follow up on too, because the cases, particularly where the court is not following the Magellan rules, really has to be challenged seriously. But the other point too I have to emphasise is, if there are law clinics attached to your universities, then the law clinics really need to be taking up this issue of whether the law students can, under supervision, appear in the standard early parts of the process. I mean, I run the law clinic at the University of Buckingham with the wonderful Julie O'Shea, who's the substantive person in that area. And we, of course, supervise interviews and so on. And so you've made me think about the potential for raising this issue in terms of the clinic I'm running, and the people who are running the clinics at ANU and at Western Sydney should, in my opinion, be thinking along these lines as well.
We also develop some standard forms that make it a bit easier for women too. And I think that we need to start looking at processes that assist traumatised women, do some form of workshop where we're pulling together this process to make it a lot easier for lawyers and those working in these systems.
And make sure that the registrars and the judges and attend these workshops too, to learn, not to dominate, to learn. Yeah, good. Okay, well, look, thank you so much. We've been very pleased to have you, Jane Matz and Stacey Carter, and appreciate your coming. We're going to take a break now. So thank you.
Thank you.
Thank you.